My name is Christopher Vallis. I'm a barrister at Old Square Tax Chambers, and today I'm going to be talking about something which on the face of it is relatively straightforward, but which in practice can be somewhat fiddly and is known to catch people out, including HMRC and the tribunal. And that is the legal mechanisms behind bringing an appeal to the tax tribunal. And at the end of the video, I'll give you a couple of examples of where HMRC and indeed the tribunal have got things wrong and the consequences of that, which is why it is extremely important to have a thorough understanding of these rules. So the first thing to keep in mind is that the tax tribunal is completely different from a court in that it is a so-called creature of statute. Its powers, everything that it can do, comes from legislation. Equally, the right of a taxpayer to have their case heard only exists because of legislation, unlike in a high court which has an inherent jurisdiction. And therefore, the tribunal, a taxpayer and HMRC need to follow the exact terms of the legislation, or a taxpayer may find themselves unable to bring an appeal, even if they have an extremely good case. Now, I'm going to be talking about appeals in the context of the Taxes Management Act 1970, so closure notices, discovery assessments, etc., is in the context of direct tax. Appeals in the context of indirect tax are similar, but the rules are slightly different. So it is important to check the rules which apply to the specific circumstances of your case. So stage one, appeal to HMRC. Now, first, I think it's important to draw a distinction between three things. There is an appeal to HMRC, there is an independent review by HMRC, and then there is the tribunal appeal. The appeal to HMRC is when you are, as the name suggests, appealing internally within HMRC to the same person usually who issued the decision that you want to appeal. And you'll be providing grounds of appeal to that person, and it gives them a chance to respond. An internal review is different because while it is still conducted internally within HMRC, usually it goes to a different team, a different department within HMRC, who will consider it from an independent perspective. And then the tribunal appeal is a separate thing, which is where it goes to a judge, an independent judge, a member of the judiciary who is not employed by HMRC, completely independent, and that is more like a court hearing. So stage one, let's take the example of a closure notice, and let's say that HMRC, having opened an inquiry into a tax return, then issues a closure notice under Section 28A of the Taxes Management Act, which amends the return. You disagree with that amendment and you want to challenge it. Can you proceed directly to the tribunal? The answer is no. If you were to make an appeal directly to the tribunal at this stage, the tribunal wouldn't have jurisdiction to hear that appeal. And this is because of the precise wording of the legislation. So if we take a look at Section 49D of the Taxes Management Act, we can see that the appellant may notify the appeal to the tribunal, but in Section 49D(1), this section applies if a notice of appeal has been given to HMRC. So, in other words, the appellant or the taxpayer may only notify an appeal to the tribunal if notice of appeal has been given to HMRC first. So stage 1 of the appeals process is to appeal to HMRC. And this usually has to be done within 30 days. In the case of a closure notice, it's 30 days from the date on which the closure notice was issued. And note that you must specify the grounds of appeal in your appeal to HMRC. If the taxpayer should miss this 30-day deadline, they can then seek permission to give notice of appeal late from HMRC, and at this stage HMRC will consider whether there is a reasonable excuse for being late. If HMRC do not grant permission, permission can then be sought from the tribunal, although they will not be considering the reasonable excuse test. They will be considering the Martland test, which is the 3-stage relief from sanctions test, and you can look at the upper tribunal decision of Martland for more information on that. So what about requesting a review? Can you go straight away and request a review before having appealed to HMRC? And the answer again is no. And if we look at section 49A, we can see that the appellant can require HMRC to review the matter in question, but only when notice of appeal has been given to HMRC. So HMRC cannot provide an independent review of the matter in question unless notice of appeal has been given to HMRC. So once the taxpayer has written to HMRC with their grounds of appeal, setting out why HMRC is wrong in their decision, this then opens the door for the taxpayer to either notify an appeal to the tribunal or request an independent review from HMRC. So stage 2, what is supposed to happen next is once an appeal has been made internally to HMRC, HMRC are to provide a view of the matter letter, and this letter should address the grounds of appeal raised in the notice of appeal to HMRC. And as I've mentioned, it's not the same thing as an independent review. So stage 3, so stage 1 is the appeal to HMRC, stage 2 is the view of the matter letter in response, and stage 3, as we've already alluded to, is to appeal, is either to request a review, an independent review, or to apply to appeal to the tribunal. So as mentioned before, an independent review is where the matter gets referred internally within HMRC to a separate team. Someone from this team will then look through all the papers and will decide whether HMRC's view of the matter letter is to be upheld, varied, or cancelled. Usually, when HMRC provide their view of the matter letter, they will offer the taxpayer the opportunity to have an independent review. And once a review has been offered to a taxpayer, they will then have 30 days to either accept the review offer or notify an appeal to the tribunal. If a taxpayer, having been offered a review, doesn't accept it within 30 days, HMRC's view of the matter letter is deemed to be settlement between the parties in accordance with section 54 TMA. Now, if the taxpayer should accept the offer of a review, HMRC should carry out the review within 45 days or such other period as may be agreed. So it may be that HMRC get back to you and say, can I have a bit more time? And if HMRC have not yet provided their view of the matter letter, it's still possible to request a review without one being offered. HMRC should then provide their view of the matter letter and carry out a review of the view as set out in the view of the matter letter. And once an independent review has been completed, the taxpayer will then have 30 days to bring a tribunal appeal if they want to. Again, if they should miss the 30-day deadline, they can seek permission to appeal to the tribunal out of time. And again, the three-stage test as set out in the upper tribunal decision of Martland applies here. So, to recap, an appeal against a relevant decision of HMRC, for example, the closure notice, must be made internally to HMRC within 30 days of that decision. This appeal must include the taxpayer's grounds of appeal. Once this has been done, a taxpayer is now legally permitted to request an independent review from HMRC or to notify an appeal to the tribunal. HMRC, having received an internal appeal, will usually issue a view of the matter letter, which will offer an independent review, at which point the taxpayer will have 30 days either to accept the offer or to appeal to the tribunal. Note that even without a view of the matter letter or offer for an independent review, a taxpayer can still request an independent review, at which point HMRC must issue a view of the matter letter and provide an independent review. And once a review has been provided, a taxpayer will then have 30 days, if they want, to notify an appeal to the tribunal. So there are various layers of things going on all at the same time. It's important to make sure that deadlines are respected, otherwise a taxpayer might find themselves requiring permission from the tribunal to bring an appeal in the first place, which slows things down and increases costs, and of course, permission may well be refused even if a taxpayer has a perfectly meritorious appeal. So, as you can see, the legislation is a little bit fiddly, and sometimes the appeals and reviews provisions are more complicated than the actual tax under appeal. Let me give you a couple of examples of where HMRC have got this wrong. And actually this example I've seen happen a number of times recently. So what happened was the taxpayer had been told by HMRC that their appeal to the tribunal was out of time and that permission was required from the tribunal to bring that appeal out of time, and HMRC were objecting to that application. And the tribunal had proceeded on that basis also. In fact, all parties were proceeding on that basis. And then I was instructed to represent the taxpayer at the tribunal to present their application for permission to appeal out of time. However, it turned out that the taxpayer had in fact requested a review, an independent review from HMRC, and HMRC had then issued the view of the matter letter, but had not actually provided the review or notified the taxpayer that they weren't going to provide a review. In fact, they seemed to have forgotten about it. So when it came to the taxpayer's appeal to the tribunal, they technically weren't out of time because the 30-day time limit hadn't started running yet. So the tribunal, in both of these cases that I'm thinking of recently, actually allowed, they didn't allow the application. They said that an application was not necessary, and the appeal to the tribunal proceeded as if there was no application because it was not necessary in the first place. Another example of where, in this case, the tribunal got things wrong was where the taxpayer had made an in-time appeal but had not attached the decision against which they were appealing to their appeal to the tribunal. And the tribunal's response was to say, this is not acceptable. Our rules require you to attach the decision that you're appealing against. Please try again. The taxpayer then tried again, but by the time they did so, the 30-day deadline had expired. And the tribunal then said, you have appealed out of time and you're going to have to make an application for permission to appeal late. And again, I was instructed to represent the taxpayer at this hearing. But before we got to the hearing, I made the argument to the tribunal that permission to appeal late was not required because the taxpayer had made an application within the deadline, and there was nothing in the TMA which required one to attach the decision against which you're appealing in order for it to be a valid appeal, and therefore in time, and that the tribunal rules were a separate stage of the process and did not invalidate an appeal made in time. And the tribunal agreed and said that in fact permission was not actually required. Thank you for listening to my short video on the mechanics of bringing an appeal to the tax tribunal. I hope I've explained why it's necessary to have a thorough understanding of these rules before proceeding down the appeals and review route. My name is Christopher Vallis. Thank you for listening.